Good evening. It's now 6 o'clock, and I'm going to hand over to Dr. Mabudi, who's going to facilitate tonight's session. Thank you.
Thank you. Good afternoon, good evening. Good evening, colleagues, and welcome to our webinar on maternity leave essentials. Now, one may ask, why would we embark on such a topic? Why are we discussing such even? Because it is taken for granted that there is maternity leave benefits, that we all have an understanding of what those maternity leave benefits are. But that is not the case. And I'm an example as well of how we do not know the full extent of the information, of the benefits available, if any. And we are all quite aware that a healthy and inclusive work environment is key to the performance of any employee. Therefore, it is important that there is maternity benefits and some security of income as well as an employment status. Globally, it's been shown that countries that do not have paid maternity leave or even the job or employment security finds that this has a huge impact on women, especially in terms of the choices that they then get to make. So it's known that paid maternity leave has an effect and a positive effect even on overall maternal health. So this encompasses the before, the during, and the after the maternity leave. That is the information that we seek. That is what the discussion today is about. We look at the legal requirements, and noting as well that there may be differences between the public sector, between the private sector, and obviously those that are in corporate, or even some of us who are self-employed. And we may have an understanding of what some of the health and safety adjustments that may be necessary in our workplace, depending on what work we do. But do we understand what rights come with that? What is enclosed or what is included in those benefits around maternity leave? It is not limited to just ensuring a salary or ensuring their job security, but it extends far beyond. And something that is not always taken into consideration is the prenatal care. When we consider that a pregnant woman has to have on average anything between 5 to 10 visits to their specialist prior to delivery. Is that included? How is that accounted for? What is, if any, are there any provisions, if any, regarding those kind of services or those kind of visits to the doctor? So it's important to discuss what the employee benefits are around maternity and also include paternity leave. It's not only maternity leave as we have come to know it, but also paternity leave. So the support that is available out there, whether before you start the journey, during, and even after, some of the HR requirements, which most of us may not even know until it is too late and we haven't registered sufficient in time or do not have the correct paperwork to access services such as the UIF, which I found out after my pregnancy, that is actually a resource that one can tap into. So as Women's Wing of Summer, this is a topic that is quite close to our hearts. It is a topic that we feel we require a lot of information on, and more than anything else, we need to equip ourselves so that we know what we are facing and what is available to us out there, and therefore can make the right choices. So as we start, please join me in welcoming Dr. Kgaugelo Manyoni. She's a medical practitioner by profession, a wife, a mother, and she is a co-founder of Life Hub Co., which is a holistic medical practice. And Dr. Magnoni will take us through what her experience is regarding such issues of maternal leave benefits or even assessment. Thank you. Handing over to you, Dr. Magnoni, and welcome.
Hi, I'm just starting my video. Good evening, everyone. Can you see my one slide, Sisanda?
Yes, I can. You may go ahead, Doctor.
Okay, thank you so much. As mentioned, I am Dr. Khagelo Munyoni, and today I'm actually just going to be giving you my perspective on maternity leave, being a clinician that has taken maternity leave actually twice now. So I've just created a few items that I think are important to consider for women and men, supporting women who are about to take maternity leave. So this list, however, it's not comprehensive. We all have our different experiences of maternity leave, of our pregnancies leading up to maternity leave. But however, I think these are just a few of the things that I'd like to highlight to you guys today. So the first thing is the pregnancy itself. You know, after you get over or after you go through the excitement of, you know, finding out that you're pregnant, you get to the realization that you're not just accountable to yourself and your family for the pregnancy, but you're also accountable to your workplace and your employers for the pregnancy. So the first thing is disclosure. When do we disclose to our employers, to our immediate managers that, you know, I am pregnant and whatever comes with it, you know, is going to come along? So the law only says that you have to disclose at least a month before you actually go on your maternity leave. But I think we know in practice, on the floor, it's quite not reasonable, especially as we advocate for people to take their prenatal days to go see their consultant, their specialists or their midwives. You know, we advocate that you disclose, you know, as soon as you possibly can. Obviously, this is up to your discretion, but, you know, to take into consideration things like taking prenatal leave and also including your safety during the pregnancy is important. Also consider that if you have a high-risk pregnancy, there may be some necessary adjustments that have to be made for you. So it's important that, you know, your managers, your employers, and your team is aware that you are pregnant so that they can accommodate you. When it comes to employer relations, you know, you often have within the healthcare, you have to disclose, like, you know, as soon as you're going for your prenatals, you have to fill in a leave form and you have to provide the evidence that from your doctor or your midwife that, you know, you saw them. So that is in itself, you know, a telltale that, you know, you disclose as early as you can. So when we disclose to our employers, you know, we also have to take into the consideration that they are not only responsible for you as an employee, but they are responsible for their departments, they're responsible for patient care, and they're responsible for workflows within the department. So oftentimes, you know, maybe our employers do not share the same excitement about our pregnancies as maybe a friend or a colleague. And we mustn't always think that is a discrimination against the pregnancy itself, but I think it is different perspectives. And the perspective of you as the pregnant one is to ensure that, you know, you do what is right for your pregnancy, and the employer is to ensure that, you know, the department is running well, and you as part of the department are also safe within the workplace. And then lastly, on the disclosure thing, disclosing to the team can be a helpful thing to do as early as possible. You know, often your team, whether you're in an internship and you're working within a team, whether you are in a registrar training program and you're in a team, or you're in a private practice and you are running as a group practice, it's important to disclose to your team members, because that is the way that they accommodate you and they accommodate your needs during the pregnancy. I will give an instance. When I was pregnant, my first pregnancy and second year internship, I didn't do any of the orthopedic theater time because of the radiation exposure. And that's just an example of how the team often has to shuffle around, reschedule themselves so that they can accommodate you. And we know that within our teams, often, we have to do calls, we have to plan things ahead. So it's important that they know that, okay, this day she's going for her prenatal care, and they preempt themselves for the time that you're actually leaving, the 4 months that you'll be taking off. So it's important for us to disclose to our teams, and this is also a great source of support during the pregnancy for the pregnant individual. I just want to touch on workplace adjustments, because oftentimes our workplaces may not be safe. It is by law that your workplace must be a safe place for you and your pregnancy. So therefore, there may be some adjustments that our employers have to implement to ensure that, the workplace is a safe place for your pregnancy, whether it is, avoiding radiation exposure, whether it is avoiding long periods of standing in a casualty, and versus you going to sit down and sort out P3 patients or non-urgent patients. There may be some adjustments that are needed to accommodate you, and should anything happen, and just to prevent and keep the pregnancy safe. So we know that the maternity leave duration is 4 consecutive months. It can be reduced to 6 weeks if you wish to do so, provided you do provide the evidence from your specialist or your midwife. It can be started 4 weeks prior to the due date, but often I know what we like to do is to add our annual leave to extend our maternity leave. In the unfortunate event that you do suffer a pregnancy loss in the 3rd trimester, you are also entitled to take 6 weeks off. And we know that during the maternity leave duration, you are paid a basic salary, your basic salary. And also to mention that it is important that prior to leaving for your maternity leave, if you're in the government sector, you need to stop your commuted overtime. So it's a form that you need to fill. And then when you come back, you have to reapply that your commuted overtime is reinstated. It was something that I overlooked, and fortunately I did it just before I left. And then just to touch on parental leave. So I remember with my second pregnancy, my husband, where he was previously, was told he's got 3 days. And I was up in arms about the 3 days, but they produced, his HR department did produce a document that showed those 3 days. And I mean, you can add your annual leave and your unpaid leave, but consider the fact that you are admitted for 2 to 3 days, or God forbid that you have to stay for an extended period of time in hospital, or your child has to be admitted. Those 3 days go by very quickly. And I think Letitia will touch on parental leave and the new changes that were done in the Gauteng High Court last year. So very excited about that. In terms of postpartum, we know the work-life balance, it's an adjustment. Having a child is a huge adjustment to anyone's life, and balancing a very busy profession and family life can be a challenge. Another point is also on the breastfeeding facilities. We as healthcare professionals, we advocate for exclusive breastfeeding for the first 6 months of life. Yet, we often struggle to provide the facilities for our healthcare professionals to do that. And not only the facilities, the work schedules that would say that you can take 2 breaks of 30 minutes to go and express or pump. So it's quite a challenge in that regard. I'd also like to say we must be cognizant that postpartum depression is a reality. And as the mother, if you do think you have those symptoms, to seek the help. And I think as teams, as people who support healthcare workers or who work in teams, we should also look out for, symptoms with our colleagues and look out for them in that regard. My last point is on career progression. So we know the HPCSA guidelines say that if you take off time during internship, you have to come back and redo the rotation that you missed. It may delay your registrar training. So there may be delays for whatever reason. And even raising a child post all of the maternity leave can actually change your ideas about how your career was supposed to progress or what speciality you want to do. But I think my parting point is to say, we are faced with our most productive years and our fertility years that coincide. And we should never have to choose. It shouldn't be a trade-off between nurturing our families and advancing our careers. So my hope is that, as we navigate maternity leave and being mothers, that we as a healthcare profession would move on to finding more flexible work schedules for employed mothers. Thank you, Susanda.
Thank you very much, Dr. Manyoni. I have to manage myself in the sense that we will be having a Q&A session at the end of our two presentations. So in the meantime, please feel free to write any questions that you have in the Q&A tab on your screen. Thank you very much, Dr. Manyoni. Absolutely very important to have a real life work and experience of what it is like. It is a challenge. It is difficult to manage. And I think your parting shot is, for me, the most important, that we shouldn't have a trade-off between our most productive years and our fertility. So thank you very much. As we introduce the second speaker, who is a medical legal advisor within SAMA and within the SAMA legal department, Mrs. Letitia Wolfswinkel. She is an attorney admitted by the High Court of South Africa, and she has worked for SAMA for 10 years prior to emigrating to live in Germany with her family for a period of 5 years. Whilst in Germany, she then obtained her LLM in intellectual property and competition law. She has returned from Germany, and we welcomed her back to SAMA. So she's been back for almost a year, and her specialty field within the legal field is in labor law, which is also, as she says, the field that she finds most interesting and rewarding. And we appreciate that because it's also the most informative for us. She particularly enjoys dealing with unfair labor practice disputes, lives in Pretoria with her husband, 2 children, and 2 dogs. And please join me in welcoming Mrs. Letitia Wolfswinkel. Thank you. Over to you, Letitia.
Thank you, Dr. Mabude. Good evening, everyone. It's such a pleasure to be presenting to you tonight. And as a mother of 2, this is an issue that's close to my heart. And I'm hoping I will be sharing some information with you tonight that will equip you with a sense of comfort in terms of what was referred to earlier by Dr. Manyoni as the work-life balance. And that you will see that after this presentation that it is possible and there are accommodations for pregnant and breastfeeding mothers. So I'm going to start off immediately. I've got quite a lengthy presentation and I'm conscious of time. So as Dr. Mabude said, please post your questions in the Q&A and we will deal with them afterwards. So I'm not going to go into much detail, but this is the authority to consider. You will find that the Constitution, the Basic Conditions of Employment Act, the Labour Relations Act, Employment Equity Act, the DPSA Directive on Leave of Absence in the Public Service, as well as individual contracts of employment, departmental policies and case law, shapes this issue of maternity leave benefits. Okay, I thought it was very important for us to distinguish between an employee and an independent contractor, for the simple reason that a lot of our private practice doctors might think of themselves as employees when in fact they are independent contractors. So what this basically means is that if you are an independent contractor instead of an employee, it basically means that you will not qualify for the benefits as set out in the Basic Conditions of Employment Act, and you will
Sorry,
also not
Letitia.
be, yes,
Sorry, Dr. Maputo, sorry to disturb you. I think your presentation hasn't shown. If
I'm
we
sorry, let me
can,
go back.
no problem.
Thank you for informing me.
Yes, I think it's
Okay, that's
loaded.
very well. Perfect. Okay, that's very well.
Let's just put it on slideshow. There we go. Okay,
Is that
perfect.
better? Can you
Much
see
better.
it?
Thank you very much, Letitia. Yes, we can see it.
Thank you
Thanks.
for alerting me to that.
Sorry to
So,
disturb. Please continue.
no problem. Thanks. It's important that everyone can see. So the reason why I'm differentiating between independent contractors and employees is not only because of the benefits of the Basic Conditions of Employment Act, which would not be applicable to you if you are an independent contractor, but also the protection offered by the Labour Relations Act in terms of unfair discrimination and unfair dismissals based on pregnancy. You will not be entitled to the protection offered there. So I want to touch on the BCA. The BCA is very important and it's applicable to all employees, public service and private sector, even though the public service employees have a little bit of, I don't want to say more benefit to public service employees, or there is actually, there is more better benefits for public service employees, which is provided for by the DPSA Directive on Leave of Absence. But I think it's important that we touch on the BCA for private colleagues to see what they qualify for. So in terms of section 19.1 of chapter 3 of the BCA, that deals with leave, this is not applicable to employees who work less than 24 hours per month for an employer. So this will affect locums that only do a couple of hours for an employer per month. So what does section 25 of the BCA says? It says that an employee is entitled to at least 4 consecutive months maternity leave. It may commence at any time from 4 weeks before the expected due date, unless otherwise agreed, and on the date which a medical professional or midwife certifies that it is necessary for the employee's health or that of her unborn child. So in normal circumstances, an employee may not work for 6 weeks after the birth, but as correctly pointed out by Dr. Magnoni, this can actually be different in the sense that a medical professional or a midwife can certify you as fit to resume duties. So an employee who has a miscarriage during the 3rd trimester or have a stillborn child is entitled to 6 weeks maternity leave thereafter. So this is irrespective of whether maternity leave already commenced. So if you've been on maternity leave for 2 weeks and something, God forbid, happens to your pregnancy and to your child, after that date on which this unfortunate event transpires, you will be equipped with another 6 weeks. So employees must notify the employer in writing, unless able to do so, of the date on which the employer intends to commence maternity leave and return to work from maternity leave. Now, Dr. Magnoni pointed out that this must be done at least 1 month or 4 weeks prior to commencement of maternity leave. But we will briefly discuss the Code of Good Practice on pregnancy later on. And I just want to mention that in terms of the Code of Good Practice on pregnancy, it basically says that employees are encouraged to share this with their employers as soon as possible. And Dr. Magnoni highlighted very important and valid reasons why this should be done. Okay, then I want us to move to the the DPSA directive on leave. So this is one of the reasons why I said public service employees are better equipped to deal with pregnancy than public service employees. The simple reason that the DPSA directive on leave provides for prenatal leave. So you will be entitled to 8 days prenatal leave, and these days can be used to attend medical examinations and tests related to your pregnancy. And you may use 1 day at a time, a full day, or you might actually chop them up and use maybe a half a day and later on use another half a day. It's the responsibility of your head of department to maintain a record of, partly utilized days. So it is the employer may ask you to provide proof of your doctor's appointments or tests. And it is, if the prenatal leave has been exhausted, you may apply for annual leave or unpaid leave, but this will be granted at the discretion of your head of department. When you experience difficulties with your pregnancy and there are medical complications, this will be covered by your sick leave, and all other maternity leave provisions as determined in the directive remain applicable. So this does not affect your maternity leave of 4 months. This is something additional that you qualify for. Okay, so paid leave versus unpaid maternity leave. Private sector employees have no automatic right to leave pay from the employer. This will be set out normally in your contract of employment. So before you sign the contract, it's wise to check whether there are paid maternity leave provided for. Your employer may decide that they do not want to pay you for your 4 months maternity leave, or they may decide to only partially pay you. So in this instance where there's no payment or partial payment, registered users of UIF may claim from the UIF. And this you may claim between 38 and 58% of your monthly salary, depending on your income level. For public service employees, you qualify for 4 months paid maternity leave, but this excludes commuted overtime, as also stated by Dr. Magnoni, and internship is extended with 4 months, registrar training is extended with 4 months, and community service period is not extended. I always, when doctors ask me about, when they phone us or write an email about maternity leave benefits, I always say to them that your community service year is the best year to have a baby, if it's possible for you to plan accordingly, because the period cannot be extended. So I want to touch on parental leave. And the BCA does not have a particular section on paternity leave. And as this presentation unfolds, you will see where paternity leave is actually dealt with. It's under parental leave. And in some instances, like with the DPSA directive, it also slots in under family responsibility leave. So an employee is entitled to at least 10 consecutive days parental leave, and it may commence on the date on which your child is born. So this can be used for paternity leave, or on a date on which an adoption order was granted, or on the date that a child is placed in the care of a prospective parent by a competent court pending the finalization of an adoption order. You will see during this presentation, I did not exclude parents or employees that become parents as a result of adoption or as a result of commissioning pregnancy. Okay, so parental leave as per the BCA, we just continue with that. The employee must notify the employer in writing, again, at least a month prior to the commencement of the parental leave. And the payment of parental leave benefits is determined by the Minister of Labour. So in this case, you will see later on when we deal with the DPSA directive that the days are paid. The DPSA directive make provision for paid paternity leave, but the BCA does not. But also, once again, if it's applicable, if you're a registered user of UIF, then you can apply for UIF. So, as I've indicated, this extends to adoptive parents who qualify for at least 10 consecutive weeks, and also a commissioning period in a surrogate motherhood agreement. They also qualify for 10 consecutive weeks. And I just want to mention that in both these instances, it should be noted that if there are two adoptive or two commissioning parents, one parent might take adoptive leave and the other parent, or adoptive or commissioning leave for 10 weeks, and the other person might take 10 days parental leave. So it's not so bad. At least there is a bit of a accommodation there. So I have some exciting news. Clearly, Dr. Magnoni is aware of it. She pointed to it in a presentation. There have been recent developments, and this is going to have a huge impact on how things are done in terms of maternity and paternity leave. So, in the matter of Van Wyk and others versus the Minister of Employment and Labour, what happened is that last year in October, the Gauteng High Court, or the Joburg High Court, declared the provisions of the Unemployment Insurance Act and the Basic Conditions of Employment Act that deals with maternity, parental adoption, and commissioning paternity leave to be unconstitutional and invalid for falling foul of the rights to equally and to equally dignify in terms of sections 9 and 10 of the Constitution. So the court found that the existing provisions unfairly discriminated between mothers and fathers, and furthermore, that it also unfairly discriminated between one set of parents and another on the basis of whether the child were born of the mother or adopted or commissioned in this instance. So what does this mean, and what is going to happen from now on? So to understand the new leave provisions, we need to point out that parents, not only women, are now entitled to 4 months of parental leave. It's no longer called maternity leave, but it's called parental leave, regardless of whether it's for the birth, adoption, or commissioning parents. This is a significant increase from a previous provision of 10 days for parental leave for adopting parents or commissioning parents. So how this is going to work is there will be a sharing of leave for couples. And this is not uncommon. I've seen this happen in many countries in the world where couples share the allowed maternity leave allocation. So in this case, it's still going to be 4 months, but the parents can decide how they want to take this. So for instance, the mother might take 3 months and the dad might take 1 month, or 2 months, 2 months, however they want to plan it and whatever works for them and is practically possible for them. So very important to note is that we await the confirmation from the Constitutional Court. So when any provision or a section in legislation is declared unconstitutional by a lower court, this must be referred to the Constitutional Court for their confirmation. So we are waiting for that to happen, and the changes are therefore not in force yet. And it will only become effective once it's confirmed by the Constitutional Court. Until then, the current law remains in effect. So I want to touch on family responsibility leave. Family responsibility leave is something that is separately provided for in the Basic Conditions of Employment Act. And this is applicable to employees who've been working for the employer for longer than 4 months and works for the employer for more than 4 days a week. So what it provides is that 3 days can be taken when your child is ill, when your life partner or spouse pass away, or when a parent, adoptive parent, grandparent, child, adopted child, grandchild, or sibling passes away. Then in terms of the DPSI leave directive, that is section 24, this provides for 3 days if the spouse or life partner gives birth, or when a child, spouse, or life partner is sick. So it differs from the Basic Conditions of Employment Act. And then it also provides 2 more days in the case of a death of a child, a spouse, or life partner, or immediate family member. Okay, so I think what a lot of our female doctors might want to know is what protection do you have before and after the birth of your child? Okay, so the employer may not require or permit a pregnant employee or an employee nursing a child to perform work that is hazardous to her health or the health of her child. And during pregnancy and 6 months after the birth, the employer must accommodate the pregnant lady or the new mother in terms of conditions that are not less favorable than ordinary terms and conditions of employment. And it should be noted that if the employee works night work, in other words, between 1800 and 6 o'clock the next morning, or her work possesses a danger to her health or safety of a child, and it is practically for the employer to do so. So reasonable accommodation must be done by the employer if in the case where there's night work, where it poses a danger to the mother or the baby, and if it is possible for the employer to do so. So the Code of Good Practice on the protection of employees during pregnancy and after the birth of a child is an extension of Section 26(1) of the Basic Conditions of Employment Act. And what it basically entails is that employers has got a duty to identify, record, and regularly review potential risks to pregnant or breastfeeding employees within the workplace. And protective measures and adjustment to working arrangements for pregnant or breastfeeding employees. So it places a very strong obligation upon the employer to make sure that the environment is safe and that you are accommodated during your pregnancy or right after the birth of your child. And where appropriate, employers should also maintain a list of employment positions not involving risks to which pregnant or breastfeeding employees could be transferred. So just to continue with the code, it's important to point out that in the code, the employers also made aware of common aspects that might affect a woman during a pregnancy. And they need to also ensure that the expecting mother is accommodated in this regard. So as a result of morning employees may be unable to perform early shift work, and exposure to nauseating smells may also aggravate morning sickness. It also considers that you might have backache and varicose veins if you are required to stand for long periods of time. And backache might also be the result of manual work. So it also includes that the employer should be aware of the fact that you might require to go to the toilet more often, and which means that you might be leaving your work unattended, and this might pose difficulties, but I'm sure it can be accommodated. And the employees increasing size and discomfort may require changes of protective clothing, and to work confined in spaces and changes to a work where manual handling is involved. It might also impair a dexterity, agility, coordination, speed of movement, and reach. And the employee's balance may be affected. And lastly, tiredness associated with a pregnancy may affect the employee's ability to work overtime and to perform evening work. And the employer must make sure to grant rest periods. Okay, so now that we've touched on how you are protected, let's say it happens that you are disadvantaged by your employer, whether it's a discrimination issue or dismissal issue. And I want to assure you that a lot of accommodation is made in legislation, both the Basic Conditions of Employment Act, the Constitution, the Labour Relations Act, and the Employment Equity Act for pregnancy. So in terms of unfair discrimination, if you are discriminated against because of your pregnancy, the discrimination will be automatically unfair. And if you should challenge this, you can get up to 24 months compensation, which would be equal to 24 months of your salary. I just want to mention something in terms of the onus of proof. An employee is to prove that there was an automatically unfair discrimination, and how you would do that is you would show that pregnancy as one of the listed grounds on which discrimination may not take place has transpired, and it's for the employer to prove, and that's all that you need to prove. And the employer needs to prove that the discrimination either did not happen or that it was fair discrimination, that there was a good reason for the discrimination. So, and not only are we dealing with discrimination issues, but also dismissal. And Section 186 of the Labour Relations Act provides protection against dismissing employees by refusing them to return to work following pregnancy. And this is not an automatically unfair dismissal. We will get to that year after. But it still means that you can challenge this as an unfair dismissal, and you can get up to 12 months compensation. And in this instance, the employee only needs to prove that there was a dismissal, which sometimes can be tricky, but in most instances, it's quite doable. And the employee needs to prove that the employer needs to prove that the dismissal was fair. Now, lastly, on this particular issue, I want to point out that a dismissal relating to pregnancy can also be automatically unfair in terms of Section 187 of the LRA. And the protection includes pregnancy, intended pregnancy, or any reason related to pregnancy. So it's quite wide. And in this instance as well, you can get up to 24 months compensation. Now, just briefly, the unfair dismissal in terms of Section 186, this one where you can get 12 months compensation, this will be dealt with by either the CCMA or the Public Health and Social Development Sectoral Bargaining Council. It would depend on whether you work in private sector or public. And the other issues, the discrimination, the unfair discrimination issue and the automatically unfair dismissal issues normally start off at the CCMA for reconciliation, where parties are given an opportunity to resolve the dispute, in which case, and if it cannot be resolved, in which case the matter would then be referred to the Labour Court. Okay, this is the end of my presentation, and I want to thank you for giving me the opportunity to address you. I'm hoping I didn't take up too much time and that we will at least have some time for Q&A. Thank you. Thank you, Dr. Mabudi. I hand over to you.
Thank you, Letitia. Thank you very much. Very informative. I probably have more questions than some of our attendees, but I will rather start with some of the questions that are there in terms of the Q&A, and just for the interest of time. But I think there's quite a few points that you raised, especially regarding what the law actually states and what changes we can anticipate, but we do note that those changes are not there yet. So if we have a look at some of the questions, I'll just group them. So I'll take the first two questions that we received. And I think you've answered it already, which was the first one, that does the antenatal doctor visits count as leave or special leave? I think you've included that for public sector employees. It is 8 days, and that is included as part of their benefits. Am I correct, Letitia?
You are correct, Dr. Mabudi. The situation is a little bit different in terms of private sector employees, as this provision is not, or this is not provided for in the Basic Conditions of Employment Act, so they will need to rely on taking annual leave.
Okay. And I think before we move on to the next question, I just a clarity point in terms of those in the private sector who are employed. You did mention that it needs to be part of their employment contract. Does that in essence mean that the private sector employers are not bound by the same rules? How do we interpret that?
Dr. Mabudi, they are bound by the same rules. They are bound by the Basic Conditions of Employment Act, but the Basic Conditions of Employment Act does not make provision for the 4 consecutive months of maternity leave to be paid. What it does make provision for is for employees to utilize their UIF benefits. So private sector employees are not entitled to paid maternity leave, and it's up to the discretion of the employer whether they want to grant it or not.
And therefore the duration of that, so whether they want to grant them paid maternity leave is up to the discretion of the employer, and what the duration of that paid maternity leave is therefore also up to the discretion of the employer, if they do provide it.
I understand what you are saying. So if they provide for it, yes. If they provide for a full 4 months paid maternity leave, that's fantastic. They can also decide that they're not going to pay anything, but you would still be entitled to the 4 consecutive months. Or they can decide that they want to do a partial payment, maybe pay you for 1 month or 2 months, or only part of your salary, a percentage thereof. So that is what the situation is in private.
Okay, thank you very much. Moving on to another question which is related to what we're talking about. So perhaps to ask, good evening, you spoke about UIF. Does that mean if you're just getting your basic salary with no commuted overtime, you're entitled to UIF?
Dr. Magnoni, no. In the public service, you will be paid your full basic salary. So you will basically receive full remuneration. And I understand why this question is being asked, because obviously you lose out on the commuted overtime. Now, commuted overtime is a little bit more complicated in the sense that overtime cannot be paid unless it's worked. And obviously during your maternity leave, you're not going to perform commuted overtime. And that will then be excluded from what you can claim from the UIF. So in other words, if you're in public service and you get your basic salary, you cannot claim your commuted overtime from UIF.
Okay, thank you. I'm moving on to the next question, and then we will move to Dr. Magnoni. It's if you take leave in internship, can you take unpaid taking 6 months so that when you come back to start with a fresh block, you start fresh with a 3-month block? So I think that's more of an operational question, but in terms of, are you allowed to add on unpaid leave onto your maternity leave?
Doctor, yes, that can be done. And it did not form part of my presentation. And I can actually see why this is coming up. And I should have actually touched on it. But the DPSI directive on leave of absence make sure that you are entitled to take annual leave. And if your annual leave is exhausted, you can even take up to 184 days of unpaid leave. But this will be dependent on whether or not the employer is going to grant it. And obviously, every single day or week or month that you miss out on in terms of your internship training needs to be worked back to accommodate the full 2 years.
All right. So thank you. So that 184 days is discretionary, but it is something that someone can apply for.
That's correct, yes.
Okay. The next question, I think Dr. Magnoni is off, so we'll just wait while she reconnects. If you're fine, Letitia, I think
I'm back,
the
Dr.
next.
Mabudi.
Oh, you are. Oh, there we are.
Yes.
Thank you. So, having heard this presentation, Dr. Magnoni, is there anything that, with your experience, highlights what we would need as information or the lack thereof amongst us as healthcare practitioners who are unaware? Because I think some of our information is quite superficial. Now, having heard Letitia's talk, is there anything that stands out for you that you think we should be better informed about?
Yeah, definitely. I think Letitia's presentation was quite extensive. I mean, myself, having gone through 2 pregnancies, I definitely learned something new today. I think it would be important to equip our healthcare workers as soon as they start internship about these things, about the procedures, about what they're entitled to, because the truth is we don't know these things, and if no one is, telling us, there's no way that I will know what it is that I need to do. I think she touched on the parental leave, which shed a lot of light, the code of good practice. It's just things that we may overlook, but at the end of the day, we don't know these things, it's not automatic, it's not told to you. You sort of fall pregnant and then it's a, find a situation. So yeah, I think if we can have a pack for all our interns, at least that's a good starting point, because everyone can receive it as they go forth in their career, a pack on essentials about maternity leave, and then we can refer back when the time arises.
Yes,
Thank you.
absolutely. Thank you. And even those of us who were interns a very long time ago, this is information that is absolutely necessary and that we need, especially in terms of the overlap between what we call family responsibility leave, or what was previously known as paternal leave, in terms of what our spouses or partners would be entitled to. So I think it's important. It is something that we should keep talking to. So back to you, Letitia, is a question: is there a limit on the number of maternity leave in a 3-year period? There's cases of women where women return to work after maternity leave already pregnant again. And I think this speaks to what we know of the leave, or the sick leave cycle, which goes in a 3-year pattern. So the question is there a limit on the number of maternity leave one may take?
That's a very interesting question. So normal leave or annual leave works in a 1-year cycle, or actually 18-month cycle, because after accumulating the days within a year, you've got 6 months within which you need to utilize them after the year comes to an end. And you're rightly pointing out that with sick leave, there's a 3-year cycle, but there's no cycle that is set out in any legislation. So that basically means that if you come back from maternity leave and you fall pregnant again within a month or two, the employer needs to accommodate you and respect your pregnancy.
Okay, thank you. Before we go into the next question about reasonable accommodation, I had my own question on that, which was in terms of the reasonable accommodation, and it makes sense in terms of the limitations that the employees, upon their return, might have. Is there a limit to that? Is that set out in terms of, if I think back, I think within the occupational health setting, there is, I think, within 6 months, and that's to allow, usually because you are breastfeeding. So what I would like to ask is, in terms of the adjustments that are made, and say you are not able to perform shift work, as an example, is there a limit to the time, or is it open-ended in terms of your employer should, upon their discretion even, reasonably accommodate you?
Okay, Dr. Mabudi, so yes, you should be reasonably accommodated, but it also depends on whether the employer can actually implement this accommodation. So with regards to breastfeeding mothers, yes, indeed, there's a limit in terms of 6 months where you must be reasonably accommodated, and also a 6-month limit on terms of, lighter duties or being transferred to a department where you are not expected to work night work, whatever the case might be. So yes, the limit is basically 6 months.
Okay. So the question in the chat is, are you obliged to resume commuted overtime just after maternity leave? What do you mean by reasonable accommodation that the employer must make when performing commuted overtime? So you answered the one part about reasonable accommodation, but in terms of commuted overtime?
That's a very interesting question. So obviously, if you are in your internship or in your registrar training, you will have to commence your commuted overtime again. if you are a medical officer or a specialist or even a community service officer for that matter, you are not obliged to again work commuted overtime. You will have to give the necessary notice in terms of your commuted overtime agreement. But we see that the employers are generally very reluctant to allow doctors to resign from commuted overtime as a result of the shortage of doctors in our country. So what we normally do is when we get queries in this regard, we assist the doctor by engaging management and negotiating on their part to see whether we can come to an agreement with the employer that they will not be forced to do their commuted overtime. But to look at the legislative part thereof, all commuted overtime contracts makes provision for resigning from commuted overtime contracts. So yes, it should be possible, even though it's usually met with reluctance, and we can assist in such instances. And we can even take it further and challenge it, if it should be that the employer is really being hard-headed about it and they don't want to accommodate the doctor.
Thank you very much, Letitia. To my dear committee member, Dr. Manyoni, I would ask you to answer the first part of this question, and then I'll pass it over to you as well, Letitia. And it's as follows: the work hours in the academic hospital is not respected and this is a known practice for years, where registrars work beyond 40 hours per week, excluding commuted overtime. Registrars get victimized if they don't abide. What is SAMA doing about this? Dr. Manyoni? Yeah.
Wow. So I think to answer the question, I think as a practitioner that is currently going through the things that you have mentioned, has this person approached SAMA to say this and this is happening? Because, we can blanket statement over it, but I think when you approach SAMA as an individual, you can get the necessary assistance versus saying all registrars are going through XYZ. So I think my advice to the individual is to approach SAMA and to hear what SAMA can do for the individual. If it is that the problem is extending beyond the individual and maybe the whole department, then SAMA can look at addressing management or the registrar training programs, whoever runs it. But SAMA does have the registrar committed committee that does address those things. So we do have the structures in place. I think what we have to do is to voice it out to the relevant people. And I know not to say that it's not happening. Look, it happens everywhere, not only to registrars, to medical professions across board. So I think once we voice it to the relevant parties, then SAMA can take the necessary steps to assist the individual or the department at large.
Thank you. I think you've answered that exceptionally well, Dr. Manyoni. Thank you very much. As we wrap up, we have roughly about a minute left. I will read the next two questions just very quickly in combination. And then if there's still any further questions in the chat group, we will ensure that we do answer them. You may find the answers within the Insider, the SAMA Insider. We will make sure that we do provide answers to some of the questions that we receive later. And it says, if you're employed before this one, it was a question on family responsibility leave. How many times is the employee entitled to family responsibility leave? And then the next one, which was, can you locum while on maternity leave if you're employed in the public sector? Thank you, Letitia.
Thank you. Very, very good question. So the first answer is that family responsibility leave runs in a 1-year cycle. So if you are entitled in terms of the DPSA directive to 5 days family responsibility leave, it basically means that you can only take the 5 days within the 1 year cycle, and you will only qualify again for 5 days in the new cycle or the new year. Okay. The locum issue, that's an interesting one. So obviously, first of all, it's going to depend on what your registration category is with the HPCs. If you are an intern or community service officer, the answer would be no. And in terms of other doctors, I would say that in order for you to do locums, you need to have an approved RWOPS agreement with your employer, because you are not allowed to perform any work in private outside of the public service if you do not have an RWOPS agreement. But yes, if you do have an RWOPS agreement, and it shouldn't be a problem for you to do some locums, but if you do not have approval for RWOPS, stay away. It's going to land you in trouble.
Thank you very much. And thank you to everyone who has attended today, to all our participants, but a special thank you to Dr. Gaugelo Magnoni and to Mrs. Letitia Volkswinkel for an amazing, engaging webinar. I am sure everyone on this platform will agree. They have been informative, it has been practical, and we have a lot to learn. Thank you very much, and good evening. Thank you.
Thank you.
Thanks.
Thank you,
Bye.
Dr. Mabudi. Thank you, Dr. Magnoni.
Thank you, Letitia. Thank you,